To the strains of London Rains, Hush and Whispers, you are back on the legal line. I'm Dennis Kennelly. My very special guest, super lawyer Dolores Leal, and we're just happy to have you back. Our topic is sexual harassment. The phone number is 661-298-5487 if you have any questions of either Dolores or myself on sexual harassment, on employment law in general, or if you want to ask an entertainment law question. We're talking about the role of the agencies, both the Department of Fair Employment and Housing on the state level and the Equal Employment Opportunity Commission, also known as the EEOC on the federal level. If you go to a lawyer in California, is your plaintiff's lawyer more likely to file a discrimination claim in federal court or state court? What's your view on that?
Well, that's a good question, Dennis, because when I was at the EEOC, we had to obviously file in federal court. Since leaving the EEOC in 1991, I tried to avoid federal court because the statute, the law in the state is much broader, much more employee-friendly, if you will, than in federal court. So, for example, under Title VII of the Civil Rights Act, there are monetary caps depending upon the size of the employer. So the amount of money that a person could recover in federal court under Title VII is limited. The maximum is $300,000, for example. In state court, under the state statute, the Fair Employment and Housing Act, which we call FEHA, there aren't any caps. It's whatever the judge decides the case is worth. Whatever injuries the person suffered, they can award whatever they want. There aren't any caps. In addition, in federal court, we need a unanimous verdict. There are 6 jurors, so all 6 persons have to agree that the law was violated. In state court, it's 9 out of 12.
9 out of 12. Much better odds for the plaintiff.
Absolutely. So that tells you why I try to stay away from federal court now. We only file in state court to the extent that we can.
And employers, in their wisdom, always try to get you into federal court by what's called removal.
That is true. And one of the reasons, again, is because of the 6-juror requirement, but also because we know that federal judges tend to be more likely to grant what are called motions for summary judgment, which is a motion where the employer seeks to dismiss the employee's claim.
Before it ever gets to a jury.
Correct, before it gets to the jury.
And isn't the California, the FEHA, isn't it more broad than the federal anti-discrimination laws?
It is broader because it also, for example, includes, let me back up. So Title VII prohibits discrimination on the basis of race, religion, color, sex, national origin, and retaliation. There's a federal statute, the ADEA, the Age Discrimination Employment Act, prohibiting discrimination against individuals 40 or older. And then there's another federal statute, the Equal Pay Act, that the EEOC also oversees, prohibiting wage discrimination based on gender. On the state side, under FEHA, an employer cannot discriminate based on race, religion, color, sex, age, national origin, medical condition. Medical condition includes cancer. It includes disability. It includes sexual orientation, which Title VII does not include. So, and it also includes retaliation. So FEHA is much broader. Oh, and I forgot, under the federal law, there's also a Americans with Disabilities Act that prohibits disability discrimination in employment. But FEHA includes everything altogether under one statute.
Including transgender and gender identity.
Correct.
Which are not covered under the federal law.
It's not covered specifically, However, the EEOC is pushing the envelope and taking the position, and they have actually filed cases across the country where they've taken the position that gender identity discrimination is tantamount to gender discrimination. So that's what's been happening the last couple of years.
Have any of those decisions gone up to the appellate level yet?
I don't know. I haven't seen any in the Ninth Circuit, to be honest with you. I don't know about the other circuits since I don't typically follow.
The Ninth Circuit, for our listeners, is the circuit that covers California, now,
Hawaii, Arizona,
and a bunch of other states, which there is some political pressure and has been for a long time to break up as too big and unwieldy. But I personally don't think that's going to happen. Okay, let's get back to the quid pro quo sexual harassment definition. Now, obviously, the example that you gave at the start of the show is the most obvious, and that is, if you want a job, you will sleep with me. But have you seen more subtle types of quid pro quo discrimination, and if so, tell us about them.
Yes, because the supervisors, managers, they're the ones, obviously, who have the authority to grant employees job assignments, salary increases, promotions, transfers to nice positions or locations. So we see that. Supervisors, managers begin to come up to employees, being nice with them, trying to become friendly. And then it comes out, well, let's go have a drink. Let's go have dinner. Let's go out to lunch. And when the employee starts refusing, is not acquiescing to these invitations, then they don't get the promotion. They don't get a salary increase. They don't get the bonus. Yet they see perhaps other persons who are playing along, who are being, quote-unquote, nice with the supervisor, who are getting those benefits. So we do see those quid pro quo cases as well.
Yeah, there was a case many, many years ago involving female correctional officers. I'm forgetting the name of it offhand, but it seems that there were the female officers that were going along were doing better. Remember that one?
I don't remember that. When you said correctional officers, there was a reported case in the Ninth Circuit that went up all the way to the Court of Appeals where it was at Pelican Bay, and the correctional officers were being sexually harassed by the inmates.
And as part of its duty to maintain a hostile work environment-free environment, the management of the prison system had an obligation to protect the guards, didn't they?
Absolutely. I mean, FEHA, the Fair Employment and Housing Act, specifically also requires employers, and I think the statute reads, quote, take reasonable steps to prevent and correct wrongful behavior in the workplace, something along those lines. So they have to ensure that the work environment is free of harassment. And then once they learn that there may be something going on, there may be some harassment, they have to take prompt and remedial action.
Starting with investigating it.
Absolutely.
Now, okay, let's say you're an employee and you're either suffering from a hostile work environment, and the simple definition of that is it's unwelcome, you feel uncomfortable. One of the keys to sexual harassment is the behavior has to be unwelcome, so that if somebody's doing something to you and you're uncomfortable with it, you've got to tell them about it and say, put a stop to it. Isn't that correct?
That is correct. Now, in hostile work environment cases, there are a number of factors or elements that we call them that have to be present. So, for example, the conduct that you're complaining about has to be based on sex. That's number one, or gender. Number two, you have to be able to prove that the conduct that you're complaining about was unwelcomed. In other words, the employee didn't say or do something that would in any way indicate to the other person that they, welcome that type of behavior. They were engaging in banter. So you have to be able to prove that it was unwelcomed. The third thing you have to be able to prove is that the conduct was either severe or pervasive. For example, I've represented women who've been raped on the job.
That sounds severe.
That's severe, absolutely. So a one-time incident is going to be enough for that particular factor, that particular element, right? On the other hand, if we're talking about sexual jokes, sexual comments, then the law says it has to be pervasive. In other words, it has to be ongoing for a relatively long period of time. If we're talking about grabbing, groping, we're talking about battery. So that goes towards the severe side, right? So that's the third element. The fourth element is you have to be able to prove liability. And the law varies depending upon who is harassing. So, for example, if the harasser is a supervisor or manager or a director, somebody in management, the law says that the company is automatically liable. It's what we call strict liability.
And that is whether top management knows about it or not, correct?
Irrespective of whether they know about it or not. Why? Because companies are entities. They can't act on their own. They act through managers, directors, supervisors. So it doesn't matter if the person complained about the harassment. It's what we call strict liability. It's automatically liable. The company's automatically liable for the supervisor's, director's, manager's behavior. On the other hand, if we're talking about a coworker, someone who is not a supervisor, who is sexually harassing another coworker, company is not automatically liable. The company is only liable if they knew about it
or should have known about it.
Or should have known about it and failed to take action.
Okay.
So that's what we look at in assessing sex harassment cases.
Now, once again, going back to our hypothetical employee who was sick and tired of, for lack of a better word, the grab-ass atmosphere in her office where people have her hands over, where coworkers are putting their hands on her all the time. What should she do?
Immediately complain,
Good.
document. I mean, a lot of these cases, I would say the majority of these cases, it's he said, she said, or she said, or he said, because you have a lot of same gender cases as well. But even though there may not be a witness, a third-party witness, when there's a groping or the grabbing taking place, if the person goes out of the room and sees the very first person they see, and they say, "Can you believe Joe just grabbed my butt?" Right? It's almost a contemporaneous reporting. So that person would then become a witness.
That's called outcry in the legal profession.
Outcry or contemporaneous reporting. So those would be witnesses. If there aren't any individuals around to whom you can say, "Oh, this just happened to me," pick up the phone and call someone and tell them, "This just happened to me."
Now, don't companies have a responsibility to promulgate or to put forward a sexual harassment policy?
There's no legal obligation that they have a policy. It's good practice to have a policy. The DFEH, the Department of Fair Employment and Housing, does have some guidelines for employers. And in those guidelines, they do recommend that employers have an effective anti-harassment policy. And if they have a policy, employers should, often distribute the policy so that the employees know that the employer takes these laws seriously, that we don't tolerate sex harassment in the workplace. In other words, they have to walk the walk and talk the talk. This is who we are. We don't tolerate. We've got a zero tolerance policy. So, yes, most companies do have anti-harassment policies.
Which should include a single person to whom to report this type of conduct.
Absolutely. Absolutely. And most companies have, for example, human resources managers, employee relations managers. If they're smaller companies, they may not have a human resources person, but always complain to someone with authority.
And do it sooner rather than later.
Absolutely, sooner rather than later, because in these cases what I hear is, well, she's making it up. There weren't any witnesses. She's making it up. And the only reason she's now saying that she's being sexually harassed by the supervisor is because she didn't get the promotion, or because we gave her a bad performance review, so she sees the writing on the wall. Perhaps she may be terminated. So she's afraid to get fired, so she sees this as a way to save her job. So that's why it's very important to complain immediately, document immediately, keep a journal.
That's what I tell all of my clients, and it seems to work. I would remind everybody the call-in number for questions, 661-298-5487. You're on the legal line. I'm Dennis Kennelly with our special guest, Dolores Leal of the Allred firm, and we will be back after this word from the station. Welcome back. You're on the legal line with Dennis Kennelly and my special guest, employment attorney par excellence, Dolores Leal of the Allred firm in Los Angeles and New York. And we were talking about hostile environment, sexual harassment, quid pro quo. Remind you that the phone number to get in touch with us is 661-298-5487. We welcome your input. We'll be happy to answer any questions you have, either Dolores, myself, or both of us. And we've outlined what the harassee, the poor victim of sexual harassment, is supposed to do. If you're a company, and I know you guys don't represent them, but what have you seen as effective strategies by company to deal with sexual harassment in the workplace at their place of work?
Well, as I said, have a policy that is distributed often to employees. That's really important. Employees need to understand that sex harassment is illegal, that it also violates company policies. The other thing I didn't mention is that the law also requires companies to train their supervisors and managers 2 hours once every 2 years about sex harassment and the laws prohibiting sex harassment. So that is training that's required. I've seen companies give online training. I don't necessarily agree that that's effective training because, a supervisor can very well turn on the training on the computer, walk away, go do whatever they're going to do, and then come back 2 hours later. And they really didn't go through the training. I think that live training is really important in order to ensure that everyone is there, everyone is participating, everyone's understanding what's going on. And so those two things are, I think, in my mind, critical. If there is a complaint filed, as I said before, the law requires employers to take prompt and remedial action. So doing a thorough and a fair investigation. And after they finish the investigation, make a decision, make a conclusion. Was there evidence to support the allegations, yes or no? If so, then you take action. And the company, the employees know, when the company takes sex harassment seriously, because I've had cases where people call, well, did you complain to Human Resources? No, it's clear. Everybody knows that Human Resources doesn't do anything. If I complain, everyone's going to find out about it, and then I'm going to be retaliated against, I'm going to be fired. So just make sure that you have a Human Resources person or someone responsible for accepting complaints who is well regarded, who is seen as though they are someone who will take action if they find something is going on at the workplace.
And one of the other keys is to make it clear to everybody, both verbally and by your actions, that if you report something, there will be no retaliation. Because
exactly.
that is the main reason I think that people don't report it.
Absolutely. Everyone is afraid of retaliation, but unfortunately there is also this legal defense and it's called the Avoidable Consequences Doctrine. And what is the Avoidable Consequences Doctrine? That means that, well, you didn't complain, says the employer. You didn't complain. Had you complained, you could have avoided all of these other incidents that you're now complaining about. So you could have avoided the consequences, so therefore your damages are cut off.
Exactly,
so,
and that's a real defense. I understand that.
Right, it is. So
with that, we're just about out of time. I think employees document, complain promptly, follow through. Employers investigate, make findings, and do something about it when you're finished. I would remind you, you've been on the legal line with Dennis Kennelly. Dolores, what's your company's website again?
It's www.amglawlaw.com.
And your phone number?
amglawlaw.com. 323-653-6530. Okay,
and everybody get your pencils out. You can get me at DennisKennelly.com. That's Kennelly. My phone number is 310-746-9106, and I'll be happy to talk to you over the phone for a free half-hour phone consultation. And I'm sure Dolores's firm has something. You can't get cases unless you talk to clients, so I'm sure they do something similar. You have been on the legal line with Dennis Kennelly. We look forward to seeing you next week. We'll be discussing some more fun wage and hour issues and perhaps the Equal Pay Act, although that's one of the most unusual laws known to man because nobody seems to understand what it is. So with that, I wish you a great rest of the week, a great weekend. The weather has improved greatly. And keep your eye on the television news because there's something even more interesting every day happening with our president. So with that, see you next week.